Good morning. The subcommittee will come to order. Without objection, the chair is authorized to declare a recess. Pursuant to notice, we are meeting to consider authorizing the chairman of the Judiciary Committee to issue a subpoena to J. Kenneth Blackwell, former Ohio Secretary of State, to assist the subcommittee in its oversight inquiry into vote suppression. This meeting will be immediately followed by a hearing into the question of voter suppression, and our witnesses, or some of them, are here already. And in the interest of those witnesses, I will not delay the hearing to allow the vote until more of our members are here. So I will declare, if necessary, a recess of the meeting, go into the hearing, and when we have the members here sufficient to consider, to vote on the resolution, we'll recess the hearing, go back to the meeting momentarily, and so forth, and then go back to the hearing. I recognize myself for an opening statement first, and this is the meeting, not the hearing. It is with no satisfaction that I bring up this resolution today, and I want to assure my colleagues that Chairman Conyers and I have made every effort to avoid it. The resolution would authorize the chairman to issue a subpoena to J. Kenneth Blackwell, the former Secretary of State of Ohio, to secure his appearance and testimony and related documents before a hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties regarding vote suppression. That is the purpose of today's hearing. This subcommittee is engaged in ongoing oversight on the question of voting rights and the work of the Justice Department in discharging its duty to enforce laws guaranteeing the fundamental right to vote. In the last Congress, with a Republican majority, this subcommittee produced a reauthorization of the Voting Rights Act, which was signed into law by President Bush. It was a matter of great satisfaction on both sides of the aisle and one of our most important accomplishments. Many members of this committee were leaders in that effort. But now we must look to enforcement of the law to ensure that rights on paper translate into rights at the ballot box. Mr. Blackwell, as the chief election officer in Ohio, presided over the contested election in Ohio in 2004. The committee's Democratic staff produced a detailed report outlining many instances in which the official machinery of the state, as well as private partisan operatives, acted in ways that may have suppressed the vote of protected minority communities. I know that Mr. Blackwell has contested the conclusions of this report, as have some of our colleagues. The job of this subcommittee is to shine a light on these serious allegations, as well as allegations in connection with elections in other states, as well as on the responses to these allegations and attempt to get at the truth. I do not believe that truth is best found in one-sided proceedings. If we are going to look at these matters, then it is best that Mr. Blackwell be present to give his side of the case. He is uniquely positioned to answer the very serious issues arising from that election. The chairman and I have written twice to Mr. Blackwell seeking his voluntary participation. He responded to our first letter in the negative. He has not responded to our second letter, which said in part, quote, "While you no longer serve as Ohio Secretary of State, we believe your prominent role in recent elections there, in which serious questions arose concerning the protection of the right to vote, gives you a uniquely valuable perspective from which to assist the committee in its ongoing oversight efforts in this important area. We are therefore writing to renew our invitation and to further advise you that your appearance will be required. Your cooperation will ensure that the committee can obtain the benefit of your testimony without the need to resort to compulsory process. If you are unable to appear at the scheduled time, please contact the subcommittee in order to arrange for another suitable date for your testimony in the near future. If we do not receive your testimony or otherwise hear from you by that time, we must assume that it is still your intent to decline to testify." Close quote. I regret to report that Mr. Blackwell did not respond to the letter in any way. To ensure that there would be no confusion, I directed the staff to contact Mr. Blackwell's office to reiterate the contents of the letter, to make clear that the subcommittee would consider this resolution today, and to seek a response, even if it was only to agree to work out a suitable date. The staff at the Buckeye Institute, where Mr. Blackwell is the Ronald Reagan Distinguished Fellow, contacted him and called the subcommittee staff back to inform them that Mr. Blackwell would be in Denver today and could not appear, period. I hope that authorizing the chairman to issue a subpoena will prove to be all that is necessary, and that Mr. Blackwell will then, on a voluntary basis, work with us to identify a suitable date to testify, and that the actual issuance of that subpoena will not be necessary. The right to vote, the subject of today's hearing, is the foundation of our other rights. It is our duty to ensure that the laws we pass are enforced and that the right to vote is protected. I can assure the members that I am determined to and intend to move forward with that work. I regretfully urge the adoption of the resolution. I now recognize our ranking minority member, Mr. Franks, for any opening remarks.
Well, thank you, Mr. Chairman. I guess, Mr. Chairman, I should probably first ask the Committee for Diplomatic Immunity, because I really feel it's unfortunate that we're dealing with this morning. Mr. Chairman, the Democratic majority of the House of Representatives adjourned the House over a week ago without passing the bipartisan Senate FISA bill that is absolutely essential to keeping America safe from terrorists. Having failed in its efforts to gather even a mere majority of the House to pass another stopgap measure that would have lasted only 21 days, the Democratic majority here in the House voted to go on vacation without passing a bipartisan Senate FISA bill that passed that chamber by an overwhelming 2-to-1 majority, and which would be signed into law immediately if presented to the President. The result is that as we sit here now, Americans are much less safe than they were 12 days ago. If tomorrow, for the first time, a terrorist suspect becomes known to us, and that terrorist is not affiliated with Al-Qaeda or any currently known terrorist group, our intelligence agencies may not have the authority to begin monitoring those suspected terrorists without a court order, even when they are foreign terrorists outside the U.S. communicating with other foreign terrorists outside the U.S. What is issue here is nothing less than thousands upon thousands of communications totally outside the United States, which our intelligence authorities had previously been able to intercept and sift through without any burdensome procedures that would prevent them from acting on the gathered information as soon as possible. But that is no longer the case, Mr. Chairman. The 2007 National Intelligence Estimate stated as follows: globalization trends and recent technological advances will continue to enable even smaller numbers of alienated people to find and connect with one another, justify and intensify their anger, and mobilize resources to attack, all without requiring a centralized terrorist organization, training camp, or leader. What that means, Mr. Chairman, is that there are now increasing numbers of terrorist enemies of America who are motivated by jihadist ideology who are not connected to previously known terrorist organizations. As of midnight, February 16th, we have been denied the ability to conduct surveillance to collect intelligence overseas on a vast number of potential threats and to help stop those threats and protect innocent American lives. So today, in its first official act since adjourning for vacation, the Democrat leadership of the House Judiciary Committee has decided to do what? It has decided to subpoena a former Secretary of State from Ohio whose only sin was to politely decline a February 5th invitation to appear at our hearing on, quote, the current state of voting rights and the allocation of resources to end voter suppression and vote fraud, close quote. Mr. Blackwell politely declined that invitation on the grounds that since he is no longer the Secretary of State of Ohio and he has not been apprised of information regarding the state's administration preparations for the upcoming 2008 primary and general elections. Having repeatedly engaged in a variety of wild goose chases that have led to dozens of dry holes, this committee is apparently setting its sights on yet another goose headed for yet another dry hole. And all the while, the Democrat leadership does not have its eye on the ball, which is the safety and security of the American people. Mr. Chairman, I oppose this frivolous waste of the committee's time, its reputation, and its resources. And I respectfully make the following motion to postpone. I move that the consideration of the Blackwell subpoena be postponed until after the House passes H.R. 3773, the FISA Amendments Act of 2008, the bipartisan bill that passed the Senate on February 12, 2008, by a vote of 68 to 29. When that is done, we can proceed to address wild geese, red herrings, and rabbit holes. But first, Mr. Chairman, please let us attend to the safety of the American people, and I yield back.
Thank you. I will decline the invitation to get into a debate over FISA. The gentleman has made a motion to postpone to a condition to a certain date. On the motion to the resolution the motion is before the committee. On the gentleman's motion to postpone, all in favor say aye. All opposed say nay.
No.
The nays have it. Recorded vote is requested. The clerk will call the roll.
Mr. Chairman? No. Mr. Chairman votes no. Mr. Davis?
No.
Mr. Davis votes no. Ms. Wasserman-Schultz?
No.
Ms. Wasserman-Schultz votes no. Mr. Ellison?
No.
Mr. Ellison votes no. Mr. Conyers? Mr. Conyers votes no. Mr. Scott?
No.
Mr. Scott votes no. Mr. Watt? Mr. Cohen? Mr. Franks?
Aye.
Mr. Franks votes aye. Mr. Pence? Mr. Issa? Mr. King? Mr. King votes aye. Mr. Jordan? Mr. Jordan votes aye.
Are there any other members who wish to be recorded? Clerk will announce the results.
Mr. Chairman, I have 6 voting in the negative and 3 voting in the affirmative.
And with that, the resolution is not adopted. The motion is not adopted. At this time, we will turn... Oh, I'm sorry. I recognize the chairman, the distinguished chairman of the full committee, the gentleman from Michigan.
Thank you, Mr. Chairman. We are now moving to continue discussion on the resolution authorizing a subpoena. Is that not correct?
Well, I'd like to have the resolution read first. If that...
All right.
Yeah, at this time, the gentleman yields back for the moment. At this time, we will turn to the resolution, which all of you have before you. The clerk will read the motion.
Resolution authorizing issuance of a subpoena to J. Kenneth Blackwell. Resolved that the chairman of the Committee on the Judiciary is authorized to issue a subpoena to J. Kenneth Blackwell to secure his appearance and testimony and related documents before a hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties regarding voter suppression.
Thank you. Does any member seek recognition?
Well, I do.
I recognize the distinguished chairman of the full committee, the gentleman from Michigan, at this time.
Thank you, Mr. Chairman and members. I only want to put my remarks in the record and assure our ranking member and friend Trent Franks of Arizona that the questions that he raised around the Foreign Intelligence Surveillance Act are appropriate ones to be discussed by this committee, probably not this morning. But I am going to take time on the floor tonight for us to talk about this in an appropriate way. And so I wanted to assure him and give him friendly notice at this point that we can carry on this conversation. It is an important one. Now, I am urging adoption of this resolution, but at the same time, I do not like to issue subpoenas. But we don't have much alternative under the circumstances that have occurred, as Chairman Nadler has quite correctly related. We always seek voluntary cooperation of the witnesses, and only where issued subpoenas are issued only when it's not possible to get anyone here and the testimony's absolutely necessary. And we have a lot of study about what went wrong in Ohio. The election appeared to be deeply flawed, and Mr. Blackwell was the chief election officer at the time. So all we're trying to do is not just look in the past about what went wrong, but to look forward toward correcting solutions that will further protect the right to vote, not only in Ohio, but everywhere. This is one of the highest priorities to which this committee has assigned itself between now and November 4th, 2008. And so I hope that it won't be necessary to exercise the authority granted in this resolution. Please understand, there is not a contempt subpoena going out today. This is voting that it will be authorized and will be able to be issued. So, Mr. Ken Blackwell, wherever you are in North America today, please know that we are not sending the gendarmes for you this morning. What we're doing is this committee is authorizing its full committee chairman to do this if we don't. Now, some people have told us that they're trying to get to us. They're going to work it out. Some have been told that he's agreed to come in. The only problem is we never can reach him, and so we're left with this task this morning. And I ask unanimous consent to insert my remarks in the record.
Without objection, does any other member seek recognition? The gentleman from
Ohio.
Ohio. For what purpose does the gentleman seek recognition?
To oppose the resolution. Strike last word, excuse me.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I oppose the resolution and want to associate myself with the remarks of the ranking member that I feel we could certainly use our time in a much better way. Look, we have fair elections in Ohio. We have 88 counties. Each county board is made up of 2 Republicans, 2 Democrats. In fact, every precinct, every polling station has 2 Republicans, 2 Democrats, and we conduct fair elections in Ohio. In fact, I would point to an article, elections officials perform well, recapping the 2004 elections by Professor Richard Smolka, Professor Emeritus at American University, and he said, one of the reasons for success in the recent elections was the important contribution by the bipartisan election boards in Ohio. And he concludes the paragraph by saying, Ohio's bipartisan model served the nation well in 2004. Mr. Blackwell has already been in front of Congress and testified about the 2004 elections, and he talked about how we had a fair election that particular cycle. In fact, you can look at, you don't take his word or my word for it. Look at all our major papers in the state have backed up what Mr. Blackwell has said. We have the Plain Dealer, Cleveland Plain Dealer. Delays at polls weren't some kind of grand scheme or conspiracy. Columbus Dispatch said this. No major election problems found after the study investigation was done. Joe Hallett, editorial writer for the Dispatch, not necessarily a friend of Republicans. In fact, this guy's called me all kinds of names, nice names in the paper in the past. He said, Democrats keep leveling charges at Blackwell they can't back up. We've had fair elections in Ohio throughout the entire tenure of Ken Blackwell. In fact, here's some facts. In the 2000 election, we had 4,795,989 votes cast in the 2000 presidential election. 4 years later, we increased turnout. We increased the numbers at the polls in the 2004 presidential election by almost 1 million voters, typically thought to be a good thing. In fact, one of the concerns that the majority party has raised about the 2004 election was Mr. Blackwell followed the law and said, if you're going to go vote with a provisional ballot, you have to do it in the county board of elections in which you live, or if you're going to the polling station on election day, you have to vote at the polling station and precinct that you're assigned to vote in, where you live. Kind of a novel idea that, you know, voters shouldn't be able to vote in places where they're not supposed. Voters without borders is not a good thing. And we found that and the chairman might be interested in this, the chairman of the full committee, we found that our provisional ballot acceptance in Ohio was the 4th best in the country. 77.33% acceptance. That compares to, just for comparison, 6.83% in Delaware, 22.5% in Massachusetts, and 57.5% in Michigan. So we had a 77% compliance rate with our acceptance rate of our provisional ballots because of Mr. Blackwell's thing there. But still, the majority wants to assume there's some grand conspiracy that we got black helicopters circling the State House in Columbus, all kinds of. It's not the truth. Think about this. Kim Blackwell was Secretary of State from 1999 to 2007. 2000 election was a pretty good election year for Republicans. He was Secretary of State. 2002 was okay. 2004, pretty good election year for Republicans in our state. 2006, pretty bad year for Republicans in Ohio. Now, think if Ken Blackwell orchestrated this grand scheme and grand conspiracy in 2000, suppressed the vote, and wound up, helping George Bush win the election. In 2006, he was still Secretary of State, and he was also candidate for governor. You would think if he could rig the game in 2004, he could certainly do it in 2006 when he's at the top of the ticket in our state, running for the highest office in our state. And yet, he got beat because we had a fair election in 2006, just like we did in 2004. Imagine that. This is as the ranking member has said, not the best use of our time. It is some grand conspiracy that I don't think.
Would the distinguished gentleman
Let
from
me finish
Ohio?
one last point, Mr. Chairman. I'd be happy to
Right.
think. I do think there is a concern in Ohio, and frankly, it's with our current Secretary of State and some of the things that she's advocating. And I'll point to one more news story, just 4 weeks old. This comes from the Lyman News, actually, paper in the district I have the privilege of representing. It's a rare combination of allies lining up to oppose current Secretary of State Jennifer Brunner's proposed voting machine changes. The Columbus Dispatch polled election officials statewide, finding more than half, representing both parties, oppose her plan. The Ohio Association of Election Officials, 10 Republicans, 10 Democrats, last week unanimously agreed Brunner's recommendations would be bad policy. They are joined by, of all people, the American Civil Liberties Union, saying Brunner is on the wrong track with her proposals, which are going to change all the things we've done in Ohio that cost the taxpayers millions of dollars to move to machines. She's going to go back to some counties using paper ballots. She's going to change all that. She's failed to seat certain Republican board members in our state. In Cuyahoga County next week, we've got a pretty big election coming up. I know your side's probably watching even closer than maybe our side is next week in Ohio. In Cuyahoga County, one of our largest counties, she's switching to an optical scan ballot next week. No second chance voting, and she's also advocating midday pickup of ballots. All kinds of potential for mischief. Mr. Chairman, as I said earlier, this is the wrong direction to go. I appreciate the indulgence of the committee and would oppose the resolution.
Thank you. A reporting quorum now being present. The question is on the resolution. Those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it. The resolution is agreed to.
I ask for a recorded vote, Mr. Chairman.
A roll call vote has been requested. As your name is called, those in favor will signify by saying aye. Those opposed, no. The clerk will call the roll.
Mr. Chairman?
Aye.
Mr. Chairman votes aye. Mr. Davis? Mr. Davis votes aye. Ms. Wasserman-Schultz? Mr. Ellison? Mr. Ellison votes aye. Mr. Conyers? Mr. Conyers votes aye. Mr. Scott? Mr. Scott votes aye. Mr. Watt? Mr. Cohen? Mr. Cohen votes aye. Mr. Franks? Mr. Franks votes no. Mr. Pence? Mr. Issa? No. Mr. Issa votes no. Mr. King? No. Mr. King votes no. Mr. Jordan? No. Mr. Jordan votes no.
The clerk will report.
Mr. Chairman, I have 6 voting in the affirmative and 4 in the negative.
A majority having voted in the affirmative, the resolution is agreed to. I thank everyone. As there's no further business before the subcommittee meeting is adjourned. This hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties will now come to order. Today's hearing will examine the problem of voter suppression and the work of the Department of Justice in protecting the right of all voters to exercise their franchise. The chair recognizes himself for 5 minutes for an opening statement. Where's my opening statement? Oh. Today's hearing is part of the subcommittee's continuing oversight over the work of the Department of Justice's Civil Rights Division and its responsibility to protect the right to vote. I can think of no more important right than the right to exercise the franchise freely, fairly, without fear or intimidation. Our nation's history is one of expanding inclusion. We have expanded the franchise to include all persons, regardless of race, color, or previous condition of servitude, gender, and age. We have enacted the Voting Rights Act, the Help America Vote Act, and the Motor Vehicle Voter Law. We have just renewed the Voting Rights Act in the last Congress with almost no dissent. The rights on paper are not the same as rights in fact. For that, we need vigorous enforcement. Efforts by both official and private parties to suppress the vote, especially if certain groups targeted by race or belief, are unacceptable. Today, we examine that problem and the extent to which the Department of Justice is faithfully discharging its duty to protect the rights of all voters. We have an outstanding lineup of witnesses. I want to welcome them, and I look forward to their testimony. With that, I yield back. I would now recognize our distinguished ranking minority member, the gentleman from Arizona, Mr. Franks, for his opening statement.
Well, thank you, Mr. Chairman. Mr. Chairman, voting is the lifeblood of a democracy, and there are no legitimate leaders in a democracy without legitimate elections. I would like to draw to everyone's attention 2 letters that were sent about a month ago to the Nevada State Democratic Party. These letters illustrate the danger posed when we cannot verify legal voters or when existing voting laws go unenforced. Both letters request an investigation into voter suppression regarding actions taken by the Clinton and Obama presidential campaigns. I will first read from the letter from the Obama campaign. Quote, I request that the Nevada State Democratic Party conduct an inquiry into an apparent and disturbing pattern of incidents reported at precinct locations throughout the state during the January 19th caucus. These reports suggest the possibility of activity conducted in violation of party rules and the rights of voters. Activity that, as the volume and distribution of these complaints indicate, may have been planned and coordinated with the willful intention to distort the process in favor of one candidate, Senator Clinton. A sheet of instructions provided by the Clinton campaign to its precinct workers captures its program for the caucus. Quote, it's not illegal unless they, the temporary precinct chairs, tell you so, close quote. This certainly suggests that for the Clinton campaign, the operative standard of conduct was simply and only what it could get away with. The Obama campaign claimed to receive well over 1,000 accounts of misconduct. Quote, those Hilary people closed the doors on our people, and we had to call the cops in some precincts to have locks cut from the doors. They slipped people in the back doors. They sent people home at 11:30 when it was illegal to prevent people from voting before noon, unquote. Another wrote, quote, in Precinct 21, a Democratic worker who was clearly for Hilary refused to register Obama supporters and said she was registering Hillary supporters only, unquote. Now let's read the letter from the Clinton campaign. Quote, the Clinton campaign wishes to bring to your attention, speaking again to the party, Mr. Chairman, we have received evidence, a premeditated and pre-designed plan by the Obama campaign to engage in systemic corruption of caucus procedures. Compounding this blatant distortion of the caucus rules was an egregious effort by the Obama campaign to manipulate the voter registration process in its favor, thereby disenfranchising countless voters. Caucus chairs obviously supporting Obama deliberately miscounted votes to favor Senator Obama, deliberately counted unregistered persons as Obama votes, and deliberately counted young children as Obama votes. Many Clinton supporters were threatened with employment termination or other discipline if they caucused for Senator Clinton. These incidents may constitute any number of very serious violations of federal elections laws. The Obama campaign's allegation that Clinton campaign workers were, quote, turning our supporters away by asking to see their IDs and telling them they weren't valid, unquote, is particularly unsettling, since such abuse could be remedied if there were a single, secure, universally recognized and accepted voter ID. My own state of Arizona has enacted just such a law. Public support for secure voter ID remains very strong, Mr. Chairman. According to the independent pollster Scott Rasmussen, quote, support for the concept is overwhelming. More than 3/4 of Republicans supported showing identification, as did 63% of Democrats and independents, 58% of blacks, 69% of whites, and 66% of other ethnic or racial minorities backed the concept, close quote. Indiana's voter ID law proves that such laws do not diminish voter turnout. Rather, and this is the important point, Mr. Chairman, rather they can increase voter turnout by giving legal voters the security of knowing that their vote will count and that it will not be negated by the vote of someone voting illegally. Curiously, it's turned out that the lead plaintiff challenging the Indiana law was actually illegally registered to vote in 2 states. Dual registration invites voter fraud, and the plaintiff actually reinforced Indiana's defense arguments. With these concerns in mind, I look forward to hearing from all our witnesses today and to exploring what Congress and the Justice Department can do to help maintain the integrity of the election process. And thank you, Mr. Chairman.
I thank the gentleman. I now recognize for an opening statement the distinguished chairman of the full committee, Mr. Conyers.
Thank you, Chairman Nadler, and thank you to Ranking Member Gary Franks, because this is not an insignificant matter that we're bringing forward. You know, the right to vote is the basis that all our democratic form of government's built on. And so I only want to add a comment from the excellent statement issued by Chairman Nadler. Because you see, too many Americans continue to face barriers preventing them from exercising their right to vote. If you don't believe that, take a look at all the work the NAACP has done, the Mexican American Legal Defense Fund, the American Civil Liberties Union, the Asian American Legal Defense Fund, to name a few. And it's become and will become obvious because of these important hearings of increasing targets of minority communities' voters of voter suppression tactics, of which there seem to be an ever-expanding number. So the critical question to be asked here this morning is, what is the Justice Department doing to protect the right to vote for all Americans, particularly in light of the upcoming presidential election now only months away? The right to vote and fair access to the ballot box are obvious the components of a truly democratic society. Now, the department's enforcement record in recent years bears scrutiny. That's why we're here. First, I'm troubled by the department's overemphasis on pursuing voter fraud cases, which were the basis of a number of the firings of U.S. attorneys and what is now widely regarded as the politicization of the Department of Justice itself. And we're pursuing these so-called voter fraud cases to the exclusion of voter suppression cases. Given the fact that voter fraud is so rare and that state law enforcement agencies are already actively pursuing individual voter fraud cases, the department's policy represents, from my point of view, a misallocation of scarce resources and misplaced priorities. Department records show 24 people were convicted or pleaded guilty to illegal voting, not last year, but between the years 2002 and 2005. That's an average of 8 people a year. While voter fraud is not to be ignored, it is unacceptable for the department to pursue voter fraud cases and disregard flagrant examples of voter suppression. Now, the next item that we want our invited guests to think about with us is the department's decision to intervene in support of the controversial Indiana photo identification law, thought to be one of the most draconian pieces of legislation of its type in the country. And it is particularly problematic because, without doubt, this law will disenfranchise minorities, the elderly, the disabled. And to make matters worse, the Department of Justice has sent letters to 10 states, Iowa, Massachusetts, Mississippi, Nebraska, North Carolina, Rhode Island, South Dakota, Texas, Utah, and Vermont, to pressure them to purge their voter rolls before the 2008 election, which could adversely affect many thousands of voters. And finally, despite complaints about vote caging incidents that occurred in Ohio, in Pennsylvania, Florida, Nevada, and Wisconsin during the course of the 2004 presidential election, the department didn't file a single lawsuit to stop this illegal practice. Instead, the department officials incredibly wrote a letter defending the GOP, the Republican efforts to engage in vote caging. And so, Mr. Chairman, it seems to me in recent years, instead of promoting access to the polls, the voting section of the Department of Justice seems to have used its enforcement authority to deny access and promote barriers to block legitimate voters from participating in the political process. The Civil Rights Division has failed to fully enforce Section 2 of the Voting Rights Act, largely aimed at combating racial discrimination in the voting process. And in the first 6 years of the present administration, fewer Section 2 cases were brought by the voting section than in any other administration since 1982. The number of Section 2 cases brought on behalf of African Americans has come to a virtual standstill. While different administrations have different enforcement priorities, it is a dereliction of duty for the Civil Rights Division not to bring voter suppression cases on behalf of African Americans to protect their constitutional right to vote. The department's role as a protector of voting rights is critical, especially as this upcoming election approaches. And already, voting problems and questionable tactics in the ongoing presidential primaries are surfacing. So please, Mr. Representative of the Department of Justice, consider these points that have been brought to your attention, and let's plan to really get to work on them. And Mr. Chairman, I thank you for the additional time that you gave me.
I thank the gentleman. The gentleman from Indiana is recognized.
Thank you, Chairman. Thank you for the courtesy and no one on this committee holds the chairman of this committee and of this full committee in higher esteem than I do. But I felt duty-bound as a loyal Hoosier and someone who also cherishes the blood-bought right to vote to speak a few moments in opening remarks on behalf of the voter ID law in the state of Indiana. Respectfully quoting the chairman, I think if I took my notes correctly, he referred to Indiana's law as one of the, quote, most draconian pieces of legislation of its type in the nation, and also asserted that it would, quote, disenfranchise the elderly and the disabled. I'd like to just say by way of opening remarks that I take exception to those characterizations of our law. And I'm anxious to hear the testimony of our witness today about the Department's decision to file an amicus brief in the Supreme Court in the Indiana voter ID law. The reality is, recent experience under Indiana's voter ID law shows that such laws do not diminish voter turnout at all. In fact, there's some evidence that they increase voter turnout. As was recently reported, voter turnout among Democrats improved slightly last year in Indiana, despite a new law requiring voters to show photo identification at the polls. Jeffrey D. Milo, a professor at the University of Missouri, compared the 2006 midterm elections, the first since Indiana's law was enacted, to the 2002 elections and said voter turnout increased about 2 percentage points. He said the increase was consistent across counties with the highest percentage of Democrats. I'm anxious to get our witnesses' sense of where this increased turnout derives. Many of us in Indiana believe that securing voter ID laws and requiring legal voters to demonstrate their identity at the polling place actually encourages participation because it gives people confidence that their vote will count and that there is fundamental integrity in the system. And let me also say that despite the characterization of this law as draconian, there's enormous public support for securing voter ID laws. According to the Washington Times recently, quote, 2/3 of Americans, including a majority of racial and ethnic minorities, say the government should make voters show photo identification before voting. 63% of Democrats and independents, 58% of blacks, 69% of whites, 66% of other ethnic and racial minorities backed the concept. And I'd love to hear our witnesses' reflections on what accounts for the popularity of these laws. I'm grateful, Mr. Chairman, for the courtesy of this opening statement. But we in Indiana anxiously await the Supreme Court's judgment in this matter. But I must say that in my humble opinion, that requiring voters to demonstrate their identity with a photo identification is the way we do at airports, the way many of us do when we're engaging in financial transactions, I believe actually encourages participation. It encourages voter confidence, and it builds on a foundation of confidence in the system that I believe is greatly in the interest of our democracy. And so with that defense of our Indiana law, I yield back.
Thank you. I would simply point out that the turnout in 2006 was way up all over the country, regardless of voter ID cards over the 2002 election. In the interest of proceeding to our witness and mindful of our busy schedules, I would ask that other members submit their statements for the record. Without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. Without objection, the chair will be authorized to declare a recess of the hearing. As we ask questions of our witness, the chair will recognize members in the order of their seniority in the subcommittee, alternating between majority and minority, provided that the member is present when his or her turn arrives. Members who are not present when their turn begins will be recognized after the other members have had the opportunity to ask their questions. The chair reserves the right to accommodate a member who is unavoidably late or only able to be with us for a short time. Our first witness today is Asheesh Agarwal, Deputy Assistant Attorney General of the Department of Justice Civil Rights Division. He heads the division's voting section. Mr. Agarwal is a graduate of the University of Chicago School of Law, and we welcome here today. Before we begin, it's customary for the committee to swear in its witnesses. If you would please stand and raise your right hand to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Let the record reflect that the witness answered in the affirmative. You may be seated. Your written statement will be made part of the record in its entirety. I would ask that you now summarize your testimony in 5 minutes or less. To help you stay within that time, there is a timing light at your table. When 1 minute remains, the light will switch from green to yellow and then to red when the 5 minutes are up. Mr. Agarwal?
Thank you. Mr. Chairman, Ranking Member Franks, members of the subcommittee, it is a pleasure to appear before you to represent the Department of Justice and the dedicated professionals of the voting section of the Civil Rights Division. I am honored to serve the people of the United States as a Deputy Assistant Attorney General. I am pleased to report that the Civil Rights Division remains diligent in protecting voting rights of all Americans. I would like to share with you some of the highlights of our work. As the subcommittee knows, the President and the Department strongly supported the recent reauthorization of the Voting Rights Act. The Civil Rights Division is vigorously defending that statute's constitutionality in federal court here in the District of Columbia. Oral argument on the cross-summary judgment motions was held in September 2007. I was proud to argue part of that case myself on behalf of the Department and in support of the law. In addition, we've had tremendous success recently under all of the statutes that we enforce. In the last 2 years, we have won 4 trials and successfully resolved 3 other cases under Section 2 of the Voting Rights Act. These cases include a lawsuit against Long County, Georgia, for improper challenges to Hispanic American voters based entirely on their perceived race and ethnicity. At least 3 of the challenged citizens were on active duty with the United States Army. We successfully resolved this matter with a consent decree. The cases also include a vote dilution suit against the city of Euclid, Ohio, on behalf of African American voters. Although African Americans comprise nearly 30% of the city's electorate, not a single African American candidate has ever been elected to the 9-member city council or to any other office. In August 2007, the court ruled that the city's method of electing its city council violated the Voting Rights Act. We are proud of this result. We are also actively pursuing other violations of Section 2. For example, we recently notified 2 jurisdictions that enforcement actions have been authorized under Section 2 based on minority vote dilution. one in South Carolina on behalf of African American voters, and one in Florida on behalf of Hispanic voters. We have also broken records with regard to enforcement of Section 208 of the Voting Rights Act. As the subcommittee knows, Section 208 assures all voters who need assistance in marking their ballots the right to choose a person they trust to provide that assistance. Voters may choose any person other than an agent of their employer or union to assist them in the voting booth. During the past 7 years, we have brought 9 of the 11 suits ever brought by the department under Section 208, including the first case ever to protect the rights of Haitian American voters. These suits help combat voter suppression. For example, in Philadelphia, a poll worker forbid a Spanish-speaking citizen with limited English skills from using her daughter to translate for her in the voting booth. This same poll worker then entered the voting booth with the voter and ultimately succeeded in mismarking the voter's ballot for a candidate the voter did not wish to vote for. We were able to resolve this matter with a consent decree. We also remain committed to enforcing the language minority requirements of the Voting Rights Act. We filed 9 lawsuits under these provisions in fiscal year 2007. During the past 7 years, the Civil Rights Division has brought more cases under the minority language provisions of the Voting Rights Act than in all other years combined since 1965. These include the first cases ever on behalf of voters of Korean, Vietnamese, and Filipino heritage. Finally, the department is busy preparing for the 2008 elections. As we have in the past, we will implement a comprehensive election day program to help ensure ballot access. As in previous years, we will coordinate the deployment of hundreds of federal government employees in counties, cities, and towns across the country to ensure access to the polls as required by our nation's civil rights laws. In identifying locations, the Civil Rights Division will again seek out the views of many organizations, including advocacy groups for minority voters, for voters with disabilities, as well as state and local officials. The division looks forward to continuing to work closely and cooperatively with this subcommittee in its effort to protect the voting rights of all Americans. I look forward to your questions.
Thank you. I will begin by recognizing myself for 5 minutes to question Mr. Agarwal. Mr. Agarwal, historically, vote caging schemes have been used to suppress minority votes. When allegations of vote caging occurred back in 1990, the Department of Justice took swift action, sending the FBI out immediately to investigate. The department filed a federal lawsuit against the Republican Party in, I think it was South Carolina, and the Helms campaign, and obtained declaratory and injunctive relief in the form of a consent judgment and decree. Has the department's position against vote caging changed since 1990?
Thank you, Mr. Chairman. The department stands ready to investigate any allegations that voters are being discriminated against on the basis of their race.
That wasn't my question. Has the department's position against vote caging changed since 1990?
Congressman, whether any particular set of circumstances constitutes a violation of federal law will depend on the facts and circumstances. If there
Excuse me, does the department, you're evading my question, does the department still regard what is commonly known as vote caging as depriving people of the right to vote as illegal?
Congressman, with respect, that term vote caging is subject to many meanings. Whether a particular
Does the department regard what it regarded as vote caging in 1990 and got a consent decree against as, are you still opposed to that?
I am aware of no change in departmental policy
Thank you.
between 1990 and today on that point.
Thank you. There were complaints of vote caging in Florida, Nevada, Wisconsin, and Ohio in 2004. How many vote caging investigations were initiated by the department in response to these complaints?
Again, Congressman, we are vigorously investigating complaints that arose as a result of the 2006 midterm elections.
Wait a minute, I asked about 2004.
Fair enough. Congressman, I joined the Civil Rights Division in the summer of 2006. To the extent that there were concerns raised about the 2004 elections, I am confident that my predecessors in the Civil Rights Division—
Were there any prosecutions as a result of vote caging allegations in the 2004 elections?
I am aware of no criminal prosecution, certainly.
Were there any other kind of prosecutions?
Not that I'm aware of.
Okay. If not, why not? Well, not if not. Why not?
Well, Congressman, I can tell you that the department has remained vigilant in protecting the voting rights of all Americans.
Well, so you say, but we're trying to investigate whether that's true. There were complaints of vote caging in Florida in 2004 in Florida, Nevada, Wisconsin, and Ohio. You're aware of no prosecutions. Were they investigated? Were these complaints investigated?
Let's take Florida if we can. I can tell you that a member of the a career member of the Civil Rights Division was on the ground in Florida in advance of the 2000 elections, was aware of the caging allegations as you described them, and worked cooperatively with state and local officials and with members of both political parties to ensure that those lists that were created ultimately were not used to challenge voters.
What happened? I mean, there were complaints after the election that they were used, obviously, in Florida, Nevada, Wisconsin, and Ohio. Did the department initiated no prosecutions? Were there reports issued by the department answering these allegations, saying they weren't true or they weren't illegal? I mean, or did those investigations just disappear into the ocean?
Congressman, again, I joined the division in 2006, so I'm not aware specifically.
Can you get to this department? Can you get detailed written answers to these questions to this committee within the next 2 weeks?
I'll be happy to take that back to the department.
Will you commit to getting written responses to this committee in the next 2 weeks? Not to take it back to the department, to get responses.
I will absolutely commit to looking into it during the next 2 weeks.
Will you commit to having a response to this committee within the next 2 weeks?
Congressman,
And the reason I'm being so hard-nosed about this is that our experience is that when we get commitments from the department to respond to us, nothing happens for years. We never get responses.
Congressman, I will commit to providing some type of written response within the next 2 weeks.
Thank you. How do you plan to address complaints of vote caging in the upcoming election cycle?
Again, we will implement a comprehensive election day program, which will include the deployment of hundreds of federal monitors and observers around the country in determining where to deploy those people.
Excuse me, that's election day. Do you plan to do anything in advance of election day about people or parties or entities or groups or whoever who send out mail to voters in minority communities with instructions to return the mail?
Absolutely, Congressman. During the next 9 months, we will meet regularly, and we have been meeting with state and local election officials, representatives of, for example, the National Association of Secretary of States, with minority groups, and we will listen to their concerns. And if
Okay, thank you. I have one further question, as my time is running out, so let me just ask this quickly. I am increasingly concerned by reports of significant staff turnover within the voting section. As you're aware, we're quickly approaching the 2008 presidential election and the 2010 census, which means there likely will be an upsurge in Section 5 submissions. It's my understanding that of the 25 experienced Section 5 analysts, only 9 now remain. What steps are you taking to ensure that there will be sufficient experienced Section 5 analysts and attorneys to accommodate the increase in Section 5 submissions, which can reasonably be anticipated because of the 2008 election and the 2010 census?
Congressman, we fully intend to have sufficient numbers of trained analysts ready to go after the 2010 census.
What about the 2008 election?
We have sufficient analysts on board today.
9 analysts is sufficient?
Congressman, in 2006, the department was able to analyze over 7,100 submissions, which was substantially greater than the numbers typically received in an election year.
And how many analysts did you have in 2006?
I don't know the number offhand, but I can get that information for you.
Because it's my understanding that the department has generally had at least 25, and that, as I said, of the 25 experienced analysts, only 9 remain. So can you get that information to us, please?
I can get that.
And how many the department has had, how many it has now, how many have any kind of experience longer than, say, 2 or 3 years?
I can get you whatever information we have, Congressman.
Thank you. I'll now yield for 5 minutes of questioning to the distinguished gentleman from Arizona.
Well, thank you, Mr. Chairman. Thank you, Mr. Agarwal. We've had a little turnover in Congress here, too, and it hasn't been a pretty picture, and I hope you do address the chairman's concerns there. Mr. Agarwal, you and your department filed an amicus brief in the Supreme Court case involving the Indiana voter law. Can you elaborate on that and tell us why you did it and what the effect of the law was in your mind?
Of course, Congressman. The department filed that amicus brief because the department determined that the issues raised in the Crawford case in the Supreme Court could affect the enforcement of federal law. including federal criminal law, and on the civil side, the Civil Rights Division's enforcement of the Help America Vote Act, which, as you know, contains its own voter identification requirement.
Well, you know, the recent experience under Indiana's voter law shows that the ID laws don't diminish voter turnout at all, but they actually increase the voter turnout. That's been our experience in Arizona as well. And voter turnout among Democrats improved slightly last year in Indiana, despite a new law requiring voters to show photo identification at the polls. Jeffrey Maglio, professor at the University of Missouri, compared the 2006 midterm elections, the first since Indiana's law was enacted, to the 2002 elections, and said voter turnout increased by about 2 percentage points. He said the increase was consistent across the counties with the highest percentage of Democrats. Do you think this increased turnout could be explained? You know, I've made this case many times, but do you think it's explained by the fact that securing voter ID laws gives legal voters the security of knowing that their vote will count and that it will not be negated by the vote of someone voting illegally, and thereby making them more likely to vote because they know their vote will be counted?
Congressman, interestingly enough, the federal district court in the Georgia ID litigation found that there was a rational relationship between the goal of deterring voter fraud and the enactment of voter ID laws. The Supreme Court has noted in the Purcell case from 2 years ago that increased confidence in the elections is something that's very important and the states have legitimate interest in.
Well, Mr. Agarwal, to your knowledge, has any court anywhere in America found that any voter has been prohibited from voting in a state that has a voter ID law because the voter did not possess a form of ID necessary to vote under that state's law?
I am not aware of a single court that has made such a finding, Congressman.
And how did the federal district court rule on the challenge to the Georgia voter ID law? And tell us, explain that to us a little bit.
Well, the Georgia court ultimately upheld that state's voter ID law. Interestingly enough, the court found that the plaintiff's expert report was unreliable. The expert had relied on data showing that the district court judge himself lacked a driver's license, and based in part on that flawed data, the court found that the report was unreliable.
Well, Mr. Agarwal, you know, there are sometimes claims made that illegal immigrants, say from Mexico, are voting in our elections, and I'm not going to really address that because I don't know what the circumstances there are. But it is interesting to me that in Mexico, one of the main elements they have in their elections is a voter ID law. They want to make sure that they can distinguish legal voters from illegal voters. And I just would say to the chairman and to the committee here that I think that it's a reasonable thing to believe that when we have confidence in the election process, that serves the cause of democracy for all voters concerned. And I believe that it will ultimately make this country more secure in its own elections, and even emphasize to the world in a greater way why democracy, why a representative form of government that relies upon everyday citizens choosing their leaders to be the best in the world. And with that, I yield back, Mr. Chairman.
Thank you, Mr. Franks. I'm assuming the chair for Chairman Nadler while he is absent. And I wanted to begin our discussion, Mr. Agarwal, by asking you, do you believe that voter ID laws increase voting among minorities?
Congressman, the department has not taken a position on the policy angles regarding voter identification laws. That's a determination to be made by Congress and by the states.
This is not a policy question I'm asking you. I'm merely asking you if you have any information, knowledge, or belief that voter ID laws increase voter turnout. That's not a policy question.
In our amicus brief filed in the Supreme Court, we did cite to the Milio study that was referenced by Congressman Pence, which did find that there was an increase in turnout after the enactment of voter ID laws in Indiana.
Well, but that doesn't lead you to answer my question in the affirmative.
Congressman, I'm really not able to answer that question at this time. I think I would need more data, but I can tell you that there have been at least this one study which did find an increase in turnout.
Okay. Well, thanks a lot. Now, we have a number of issues in my opening statement, which I'm going to give you a copy of before you leave, because these weren't just rhetorical remarks. They were issues that we need to have answered specifically. Would you be willing to go through my opening statement and respond to them?
With pleasure, Congressman.
Thank you. Now, with regard to the Tim Griffin case in Florida, in which members of the other body, White House and Kennedy, called for a Department of Justice investigation into allegations that Tim Griffin in Florida, a former Republican National Committee opposition researcher, and others at the RNC may have engaged in caging during the 2004 elections. Are you familiar with that matter, or have you heard about it?
I have heard about it, yes.
All right. Is there any indication, or do you have any information that there is a Department of Justice investigation ongoing in that matter?
I am aware of no such ongoing investigation within the civil rights or criminal divisions, Congressman. And I should also mention that the department recently sent a letter to the Senate indicating that at least as of 2007, the department had not been aware of those allegations.
All right, and the letter was sent to Senator Kennedy and Senator Whitehouse?
I believe so, or perhaps Senator Leahy, but yes.
So there's been nothing done about them, or it looks like there won't be any, even an investigation.
Congressman, as I said during my opening statement, the department takes very seriously any allegations that voters are being discriminated against on the basis of their race, and I think we have an outstanding record of bringing lawsuits where necessary to protect the rights of minority voters.
Well, yeah, but that doesn't answer my question. That's a wonderful statement on behalf of the Department of Justice, but you're doing nothing in this case. You don't feel that. Well, I guess I have to interpret for you what you're saying to me is that because you're so concerned about this issue and nothing was done, this must not have had any merit to justify an investigation. Is that what you're telling me in the way you talk in the Department of Justice?
Congressman, whether any particular factual allegations raise an issue of a violation of federal law depends on all the facts and circumstances. If the
Well, of course.
Or
I mean, how else could we operate since the Department of Justice has been depoliticized? But what's that got to do with what happened in this matter? I'm trying to find it out. Can we save a little time and you get back to me on this matter? Since I didn't get a letter, and you're the first to tell me about it.
Congressman, we will be happy to take a look at any allegations the congressman thinks raise a possible violation of federal law.
Well, I want you to get back to me even if it doesn't raise a violation of law. I'm trying to find out what happened to it, not what you think about it.
I'll take that back to the department, Congressman.
Okay, thank you very much. You know, I don't get the sense of cooperation, and maybe it may be my attitude and not your attitude. But, you know, you can fine-tune these responses and shade them all you want, but we've got to get to the bottom of this problem. I understand that you're representing the department, and you've got to come here prepared to defend the department. I don't expect anything else. But you could save us a little time because this isn't going to work anymore. I don't know where you testify, probably a lot of places, but we've got to get right down to the facts, sir. I'd appreciate a little more definitive response rather than us having to qualify, if you can.
Absolutely, Congressman. With apologies, I did join the division in 2006, but I'll be happy to get the information that I
Okay.
can for you.
Well, I joined the Congress in 1965, but nobody holds me responsible for everything that's happened either before or since then. And I'm not holding you responsible to know about everything that happened before 2006. Not at all. I'd like now to turn to my good friend Mike Pence from Indiana.
Thank you, Chairman. Again, I'd like to welcome our witness, and thank you for your service to the country from 2006 before and since. A couple quick questions about the Department's view of the Help America Vote Act. Specifically here, my understanding, Article 1, Section 4 of the Constitution delegates to the states broad authority to regulate the conduct of federal elections. Help America Vote Act passes Congress in 2002. Is it the Department's judgment that in effect, supplanted the preeminence of states in the administration of elections, or is it intended to supplement? What is the Department's view?
Thank you, Congressman. The Help America Vote Act sets a certain floor that states need to satisfy. For example, they need to meet certain database requirements. They have to comply with certain posting requirements for language minorities, but states are free to enact other legislation.
So, forgive me for interrupting, but so it's very much a floor, but states are not invited necessarily, but certainly under the Constitution are free to have additional requirements on top of that basic.
That's absolutely correct, Congressman.
I want to get into what Indiana's done, but also some of the Carter-Baker recommendations. But let me say to begin with, and I think this is reflected in the tone on both sides of this committee, and this is a very serious issue. I don't take this at all lightly. I don't take the concerns of the chairman of the subcommittee or the chairman of this committee lightly at all. I believe that the integrity of a vote is the integrity of a democracy, and that happens one vote at a time. So don't misunderstand what may be my parochial pride in what Hoosiers are attempting to do as in any way diminishing the dreadful seriousness we think about which you are charged and this department is charged. That being said, are you familiar with the Carter-Baker Commission and its recommendations? I know that
I am,
predated.
Congressman.
Is it accurate that the Carter-Baker Commission convened after the '04 presidential elections, which of course were fraught with controversy on these topics, that among those recommendations in post-Help America Voting Act reforms was, and I'm quoting now, that this bipartisan commission suggested, quote, to ensure that persons presenting themselves at the polling place are the ones on the registration list, the commission recommends that states require voters to use the Real ID card, which was mandated in a law signed by the president in 2005. Is it accurate to say that bipartisan commission recommended photo identification requirements at polling places?
That's certainly my understanding, Congressman, and I would add that those recommendations were also supported by former UN Ambassador Andrew Young.
Former UN Ambassador Andrew Young.
Correct, who had been UN Ambassador under President Carter.
Let me see if I can get an answer specific. Are you aware of any instance where the Justice Department has been called upon to investigate allegations of a voter being disenfranchised at the polling place as a function of a photo identification law like Indiana's?
Congressman, that's an excellent question, and no court has found that a voter has been prevented from voting because of a voter ID law.
Now, in the state of Indiana, we have worked hard to accommodate and to alleviate any hardship that a photo identification, I'm sure you're aware of our law the brief the Justice Department's filed. Indiana's made provision for people who can't afford to pay for a photo ID. We've also give people who don't have a photo ID a chance to file a provisional vote, and I think it's a week to 10 days that they can then come back and present. With regard to other states, do other states do as Indiana has done and provide those kind of accommodations to ensure that individuals are not disenfranchised?
That's correct, Congressman. They do. I believe that most states do have alternate procedures to vote for voters who may lack photo identification. And
so, again, to go back, now you said to me no court has found that an American citizen entitled to vote has been deprived of their franchise to vote by virtue of photo identification laws like Indiana's. But let me ask you specifically, as my time runs out, are you aware of any, is there any complaint before or allegation before the Justice Department, to your knowledge today, of an individual who says that they were deprived of their right to vote because of a photo identification law?
I'm not aware of any such allegation that would raise a, obviously the department has limited jurisdiction. I am not aware of any information that is presented to the department that would constitute a violation of federal law. So the answer is no.
Okay. I want to, out of courtesy to my colleagues, I'll yield back. I thank the chairman.
Thank you. The chair recognizes the distinguished gentlelady from Florida, Debbie Wasserman Schultz.
Thank you, Mr. Chairman. Welcome to the committee. I have a couple of questions related to the National Voter Registration Act and Section 7, because as you know, and we've been discussing that this morning, that it requires states to provide assistance to voters in public agencies when they are there for other benefits to register to vote. And a study produced by Acorn and Project Vote, called Unequal Access, Neglecting the National Voter Registration Act, 1995 to 2007, showed that voter registrations generated from public assistance agencies nationwide have declined 79% between 1995 and 2007, when the National Voter Registration Act was first implemented, and 2005 and 2006. Here are my concerns. In your written statement, you assert that since 2006, the voting section filed lawsuits containing NVRA claims in Indiana, Maine, New Jersey, Philadelphia, and Cibola County, New Mexico. And it's my understanding that 4 of the 5 lawsuits were filed not to enhance voter registration opportunities, but instead to force states to conduct massive purges of their registration lists under Section 8 of the NVRA. Is this correct?
Congresswoman, we have filed 10 lawsuits under the NVRA during this administration. 5 of them included allegations that states were improperly removing voters from the polls, and 2 of them were under Section 7. I should also add, if I could briefly, that in 2007, we sent 18 letters to different states regarding their compliance or lack of compliance with Section 7 of the NVRA, and it's my understanding that at least 2 of those states have already begun the process of drafting legislation.
Okay,
to
but excuse me, the purpose of Section 7 is not to ensure that states are purging voters, but to ensure that they're registering voters. So why would half the lawsuits that you filed deal with the purging of voters?
Well, Congresswoman, we filed 2 lawsuits under Section 7 during this administration. We're prosecuting one of them. And in 2007, we sent out 18 letters.
But are you also pursuing states to ensure that they purge voters that you don't believe belong on the rolls?
We enforce all of the provisions of the NVRA.
I realize that. But are you more aggressively pursuing states to encourage them to purge voters rather than pursuing Section 7, which ensures the registration of voters? I would think that it would be more important for the department to be ensuring that we have more qualified registered voters on the rolls, as opposed to making sure that we aggressively purge voters when much of that purging in recent years has shown to be overly aggressive and purged voters who were valid and belonged on the rolls.
Congresswoman, we're enforcing both Section 7 and Section 8.
I realize that, but are you more aggressive? I mean, I think just looking at the percentage of lawsuits that you're pursuing, the numbers bear out. If you're only pursuing 2 Section 7 lawsuits and the others relate to purging of voters from the rolls, then I think one could logically conclude that you are more aggressively going after states to ensure that they purge. Is that the case?
With respect, Congresswoman, I would disagree with that characterization because 5 of the 8 Section 8 lawsuits that we've brought do include allegations that the jurisdictions were improperly removing voters.
How do you explain a 79% decrease in the number of registered voters that were added to the rolls if you have been aggressively ensuring that Section 7 is enforced?
Congresswoman, I am aware of that study, and that's part of the reason why we sent out 18 letters in 2007 to gather information regarding states.
Well, good. I'm glad you raised those 18 letters. When we're talking about the 18 states that you did send letters to, that was just a few months ago on August 30th, 2007. You began that inquiry, and you sent letters to Vermont, Alaska, Alabama, Arizona, Connecticut, Hawaii, Iowa, Illinois, Massachusetts, Maine, Michigan, Mississippi, Montana, Nebraska, New York, Pennsylvania, Utah, and South Carolina. Now, Florida, Texas, and Virginia also ranked in the bottom 10, and they did not receive letters. So can you answer why you chose not to send letters to Florida, Texas, and Virginia, and and if not, then why have you failed to take measures to ensure that all of, including the worst offenders of Section 7 violations, were included in your pursuit?
Congresswoman, with respect to the letters that we sent out, we did not send out letters to every state because
you sent out 18. Why not 21?
With respect to some states, Congresswoman, we already had and continue to have substantial information, and so there's simply no need to
well, why not
send out letters.
Well, wait, why not Florida, for example? I'm a little partial to Florida, as you might imagine, where we specifically have had egregious violations of purging voters from the rolls, the use of lists that were inappropriately used, of felons who turned out not to be felons. Why have you excluded Florida and not pursued Florida and sent them a letter? We're in the bottom 10.
Congresswoman, I don't know the answer to that, and with respect, it would be inappropriate for me to comment
Mr. Chairman,
on.
if you could ask the witness to answer that question specifically and include it in the information that you asked, that the chairman of the subcommittee asked for in the next 2 weeks, I would appreciate it.
You heard her request?
I will take that back to the department, but I should add that the department cannot get into,
The department
disclosing our deliberative process and determining where we're.
They can certainly tell us why they chose to exclude one state that was in the bottom 10 and had among the most egregious violations of Section 7. I don't think that's something that you're not permitted to disclose.
I'll be happy to take that back to the department.
Thank you very much. I yield back.
Thank you very much. The chair recognizes the distinguished gentleman from Minnesota, Keith Ellison.
Wasn't too long ago that John Tanner was here before us, and he had been reported as saying that while it's a shame that elderly voters may be disenfranchised by a new voter ID restriction at the polls because many of them don't have driver's licenses, minorities don't have to worry about that because they die first. Remember that?
Yes, Congressman.
Was he right?
Congressman, Mr. Tanner has apologized for those comments.
I didn't ask you whether he apologized. I asked you whether he's right.
Congressman, Mr. Tanner has apologized.
Is he
for
right?
those comments.
Is he right or not?
Congressman, Mr. Tanner has apologized for those comments.
I heard that answer. I'm asking you whether he's right. Are you declining the answer?
He has stepped down from
I
his
want to
leadership.
ask you if you are refusing to answer my question.
Congressman, Mr.
Are
Tanner,
you refusing to answer my question?
Congressman,
Well,
Mr.
then answer
Tanner
it.
has apologized for those comments.
I heard
He
you
has
say
stepped
that.
down from his leadership role.
I
in the
heard
department.
you say that. Was he right?
Congressman, I'm not here to throw dirt on John Tanner. He
Well, let me
was
ask you
a
this.
dedicated.
Let me ask you this question, because I'm not asking you about whether he's dedicated or not. I'm asking you whether he was right, but you don't want to answer. So let me ask you this. When he said that seniors, older voters, senior citizens will be disenfranchised by new photo ID restrictions at the polls, was he right about that?
Congressman, I can tell you what courts have found on that point.
I know what report. I want to ask you if he was right or not. Are you familiar with the Wisconsin study that was done in June of 2005 at University of Wisconsin?
I'm not sure that I am, Congressman.
Okay, well, there was a study out there, and you're the deputy of the voting rights section, right?
I'm a deputy assistant attorney general.
Right, right. And I would assume that since you know all about other studies, that you'd read the literature out there. Are you telling me that you're not familiar with the June 2005 University of Wisconsin study on the impact of photographic identifications on voters?
Congressman, there are a lot.
You don't know about that one.
There are a lot of studies out there.
Just tell me whether you know about it or not. Say yes or
Not
no.
offhand, I do not know.
Okay, well, I did. I read that study, and I read the one you talked about as well. And in the University of Wisconsin study, it estimated that 23% of the people aged 65 and over did not have a photo ID. Do you dispute that? No, because you didn't read the study. Good point. Less than half of the Milwaukee County's African American and Hispanic adults did not have a valid driver's license or photo identification, compared to 85% of their white counterparts who did. Are you familiar with that finding?
No, Congressman, it's interesting. That
Are you familiar with that study or not? Are you familiar with that finding?
There have been a lot of findings made by a lot of studies.
I'm asking about this finding. Just say yes or no.
I'm not familiar
Why
with
can't
that
you?
particular
Thank you.
study.
So that would be no. All right. Are you familiar with the other finding that stated that for young minority adults, ages 18 to 24, about 26% of the African American youth and 34% of the Hispanic youth had a valid driver's license, compared to 71% of their white counterparts who did. I guess you don't know about that one either, huh?
Congressman, I'm familiar with a lot of studies. I can tell you what courts have
I'm not.
found
There's no
respectively.
question in front of you right now, sir. I'm gonna ask you to wait till I get my question ready. Let's just talk about Indiana for a moment. Now, I wrote an amicus brief opposing the Indiana statute because it is unconstitutional. Are you familiar with the 24th Amendment?
I believe so.
There's a lot of those too. Do you know that one?
I'm familiar
What
with
does
the
it say?
Constitution.
What does it say?
Congressman.
What does the 24th Amendment say?
It's the poll tax amendment.
Good, right answer. And doesn't it say that to impose a financial barrier to voting is unconstitutional?
I don't have the language in front of me, but that's the gist of it. Correct.
Right. And to acquire a photographic ID would require some money, right?
Well, in Indiana, the
How
state
much does it
provides
cost? How much does ID cost in Indiana?
well, the state does have provisions for free.
I'm not asking
photo
about that. I'm asking you how much an ID costs in Indiana.
Well, I don't know the answer to that, but I do know that Indiana provides for free photo ID.
Okay, what do you have to do to get a free ID? Do you have to state your economic status to get a free ID?
Yeah.
Do you have to state your economic status to get a free ID in Indiana?
There is an
You are the Deputy Attorney General. You should know this. Do you have to state under oath, state your economic status to get a free ID?
There is an indigency exception under Indiana law. I'm
And
not
do
familiar.
you have to state your income to apply under that exception?
I'm not familiar with all of the requirements of
Well,
the
I am,
indigency
and you do.
exception.
As a matter of fact, the 24th Amendment says that economic status cannot be a barrier to the ballot box. And to have to swear that you're poor to get a free ID is requiring that making income a barrier to the ballot box. The Indiana law is a flagrant violation of the law, and I look forward to it being struck down as unconstitutional.
The chairman of the Crime Committee on Judiciary, Mr. Bobby Scott.
Thank you very much. I just had a couple of questions and just wanted to ask the witness's position on what the department's position is when you find that there has been a campaign to intentionally mislead voters as to their eligibility, their right to vote, the location of the polling place, or otherwise misleading people into possibly missing their opportunity to vote. What is the department's position on that?
Sure. If there are credible allegations of that, we will absolutely look into them. It could very well be a violation of either Section 2 of the Voting Rights Act or, depending on the specific fact and circumstances, possibly federal criminal law as well.
And so if people are passing out literature suggesting the wrong date for the election, or the polling place has been moved when it in fact hasn't, or something like that, there could be a criminal violation?
That's correct, Congressman.
And do you prosecute such activities?
We certainly have the ability to do so, and we certainly would look into those types of allegations.
Have any allegations been brought to the attention of the Civil Rights Division? to your knowledge, since you've been there?
We have been looking into allegations regarding events that occurred during the 2006 midterm elections. For example, in Orange County, some information was sent primarily to minority voters. We immediately contacted state and local officials, have been working with them, and currently our criminal section within the Civil Rights Division is looking at that matter.
And so if there are other examples of that that are brought to your attention, we can count on the division, Civil Rights Division, to follow through both civilly and criminally?
Absolutely,
if
we'll take a look at
appropriate,
it.
if appropriate.
Absolutely.
Voter caging, what is the Civil Rights Division's position on voter caging?
Well, again, as I tried to explain earlier, whether a specific set of facts raises a violation of federal law will depend on all the facts and circumstances. It is not illegal simply to challenge voters absent any other facts. If there is evidence that voters are being targeted because of their race, that could potentially raise issues about a violation of Section 2.
Is additional legislation appropriate to clarify that so that there is no question that a campaign targeting people because of their race for challenges would be illegal?
Again, if any legislation is submitted, the department will certainly be happy to take a look at it.
Does the Civil Rights Division have a position on these computer voting machines where you cannot get a recount?
Congressman, with respect, the issue of election equipment is one that is primarily handled by the Election Assistance Commission. We have a very narrow piece of that pie in ensuring under HAVA that election equipment is accessible to voters with disabilities.
If it were ascertained that the equipment had discriminatory impact, that is, that there are a lot more mistakes or undervoting in certain communities than others, would not that have a civil rights implication?
Potentially, and if there are such allegations, again, we'd be happy to take a look at them.
There is a. Are you familiar with the report produced by the Asian American Legal Defense and Education Fund entitled "Asian American Access to Democracy in the 2006 Elections"?
I believe that I have seen that, yes.
They allege excessive inquiries for voter identification for Asian Americans that others were not subjected to. What would, if those could be sustained, what would the Civil Rights Division's response be?
We would absolutely take a look at bringing a lawsuit under Section 2 and/or Section 203 of the Voting Rights Act. We've done so in many instances already. We filed 27 lawsuits under the language minority provisions of the Voting Rights Act. That's more than 60% of language minority lawsuits ever brought under the Voting Rights Act. I can give you a concrete example, if you like. In Hamtramck, Michigan, Bangladeshi and Arab American voters were singled out and had their right to vote challenged. A consent decree was entered into. We extended that consent decree during this administration, and as a result of our consent decree, the poll workers in the state of Michigan now have to train poll workers to prevent that sort of thing from happening.
My time has expired. The report. Are you following through on the allegations in the report?
Absolutely, we are.
Okay, Mr. Chairman, I'd ask unanimous consent that the report that I've just referred to be made part of the record.
Without objection.
Thank you.
The gentleman's time has expired. I now recognize the gentleman from North Carolina.
Thank you, Mr. Chairman.
5 minutes.
It's quite apparent that we're not getting many straight answers here, so I'm going to try to just close this out with some softball questions. Since you're not going to answer any hard questions today, it's quite obvious. I've been sitting here the whole time, and it's always that happened before I got to the department, or I'll take that back to the department, or I'll take that under advisement, but getting a straight answer out of you is about as difficult as it is getting one out of the Secretary of Housing and Urban Development when he comes before the Financial Services Committee. Can you just give me a 1-minute summary of the arguments on the constitutionality of the Voting Rights Act extension, what position the department is taking, and what position the other side is taking?
Sure. The arguments that were raised by the plaintiffs are that the Voting Rights Act, as reauthorized in 2006, is no longer congruent and proportional to the harm that it was designed to address, namely racial discrimination. And the arguments are that there are fewer Section 5 objections interposed today and in the recent past than there were in the immediate aftermath of 1965 and the 1982 objections. Our brief and argument focused spent a lot of time focusing on the evidence of continued racial discrimination.
Okay. That was a pretty direct answer. I appreciate that softball question. Can you tell me how many folks in the last 8 years that you all have been pursuing more aggressively voter fraud cases? How many people have been found guilty of voter fraud?
My understanding from the criminal division is that that number is 86.
86. And so all of this emphasis that we've placed on keeping people from voting who should not be voting nationwide has yielded 86 cases of voter fraud.
That's correct, Congressman. I would add.
Okay. I'm not. That's not a trick question. I'm just summarizing what you said. Would it be fair to say that this department in this administration has put more emphasis on catching people who might be trying to vote, although they are not qualified to vote, than they put on trying to enhance the ability of people who would really like to vote, who for one reason or another have been prevented from voting?
I would disagree with that characterization, Congressman. I think under Attorney General Ashcroft, he sought to increase federal enforcement of all the election laws, both on the civil rights side and on the criminal side.
Okay. All right. I guess I would expect you to say that, but I don't think the numbers really support what you're saying, and certainly the sense in communities around the country is that the department has been much more obsessed with trying to stop people from voting who are not eligible to vote than they are trying to enhance the ability of people to vote who are eligible to vote, which was the original and historic purpose of the Voting Rights Act. But I suppose if that's your emphasis, that's your emphasis. So we can go on. I'm the last person to ask questions here, so we can go on to a more balanced picture of that. But I appreciate you coming and testifying.
Thank you, Congressman.
Thank you, and I thank the witness. That's the conclusion of our questions in panel one. I thank the witness, Mr. Agarwal, and I'd ask that our second panel now join us. To save time, while we are switching panels, I will read the introductions, which I would normally do when everybody has gotten their seats, but I'll do it now. The first witness for our second panel is Gerald Hebert. Gerald Hebert, Executive Director and Director of Litigation at the Campaign Legal Center, a nonpartisan organization that focuses on campaign finance and voting rights. For nearly 20 years, Mr. Hebert served in many capacities at the Justice Department's voting section, including as Acting Chief, Deputy Chief, and Special Litigation Counsel. Mr. Hebert also has his own private practice where he specializes in voting rights and redistricting. Mr. Hebert is an adjunct professor at Georgetown Law School. A second witness is Hilary Shelton, Director of the Washington Bureau of the NAACP. In that capacity, Mr. Shelton advocates for the organization's federal public policy agenda, including voting rights protection. Prior to his position at the NAACP, Mr. Shelton served in the Government Affairs Department of the United Negro College Fund and the Social Justice Agency of the United Methodist Church. A third witness we hope, I don't see him here, but our third witness is supposed to be, is coming, we hope, is Minnesota State Representative Tom Emmer. Mr. Emmer was first elected to that office in 2004 and currently serves as the Deputy Minority Leader in the Minnesota State House. A final witness this morning is Lorraine Minnite, Assistant Professor of Political Science at Barnard College, where she has taught American and urban politics since 2000. Prior to teaching at Barnard, Dr. Minnite served as the Associate Director of the Center for Urban Research at Columbia University School of International and Public Affairs. She's also conducted extensive research into issues of equality, social and racial justice, political participation, and voting behavior, to name only a few. She is currently working on a book on the politics of electoral rules called The Myth of Voter Fraud, which is a subject of some relevance to our hearing today. Before we begin, and I see all our witnesses are here, it is customary for the committee to swear in its witnesses. If you would all please stand and raise your right hand to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief?
I do.
Thank you. Let the record reflect that the witness is answered in the affirmative. You may be seated. As a reminder, your written statements will be made part of the record in its entirety. I would ask that each of you now summarize your testimony in 5 minutes or less. To help you stay within that time, there's a timing light at your table. When 1 minute remains, the light will switch from green to yellow and then to red when the 5 minutes are up. Our first witness is Mr. Hebert.
Thank you, Mr. Chairman, for the opportunity to testify this morning. Mr. Franks, Ranking Member, good morning to you as well. I'm going to talk about two issues in particular today. The first is vote caging and how it's been used to suppress minority votes.
Is he talking?
And second, I'm going to talk about the Justice Department.
Yeah, would you turn your mic on or speak into it, one or the other?
And second, I'm going to talk
That's
about the Justice Department's failure to enforce many of the provisions, not only of the Voting Rights Act, but other federal statutes that should be designed to protect the right to vote. Vote caging, in this context, involves sending out non-forwardable or registered mail to targeted groups of voters and compiling caging lists of voters for those whose mail is unable to be delivered. And although the NVRA prohibits election officials from canceling voter registration merely because a piece of mail has been returned, political operatives, primarily in the GOP, have used these type of tactics and lists, called caging lists, for many years. They've been enjoined time and time again by federal courts in caging operations that have challenged thousands of minority and urban voters nationwide on the basis of returned mail. To bring these types of schemes to an end will require vigorous prosecution by the Justice Department, but this Justice Department's priorities have shifted over the years, and I ought to know because I spent 21 years there and I was the acting chief of the Voting Rights Section for a number of them. The current administration has not only ignored voting caging schemes, but has actively worked, as I think the chairman pointed out, in Ohio, to actually give vote caging schemes a boost in the federal courts by actually defending them in Ohio. Now, I know that I have limited time today, so I'm going to talk in particular about a couple of things. I think Mr. Watt and perhaps Mr. Scott and Mr. Ellison asked questions about what the Justice Department has done in trying to get a straight answer about, well, are there any voting caging schemes under investigation right now? And, you know, Mr. Agarwal's testimony this morning is that he wasn't aware, as I recall what he said, of a single instance or an investigation even being conducted. So how could they even possibly know at the Justice Department if there's been any illegality in these voting schemes if they haven't done any investigations of them? I mean, that's just basic law enforcement 101. With regard to vote caging schemes, I personally have written letters to the Justice Department bringing to their attention instances in which minority voters have been targeted by political operatives, and we don't know who. They could be Democrats, they could be Republicans. But black voters in Dallas, Texas in 2006, after Mr. Agarwal joined the Justice Department, received a letter that said, if you were registered by Acorn, they're a fraudulent organization, and if you try to vote, you will be prosecuted and arrested at the polls. Justice Department hasn't even investigated that matter, even though it was brought to their attention. And there are other examples that I could get to along those same lines. And to suggest that the Justice Department didn't know about the Tim Griffin vote caging scheme, they must have had their head in the sand, because everybody knew about that. It was reported on the BBC years ago. And there's a book out about it. So it's just incredulous for somebody to assert that. With regard to the department's enforcement of basic laws that are supposed to expand the right to vote, look at the NVRA. The NVRA, the Motor Voter Bill, was enacted primarily to get more people, to make it easier for people to register to vote. Its primary purpose wasn't to purge voting lists. But what the Department of Justice has done, and Mr. Agarwal again says, oh, since 2006, we filed 5 cases to enforce the NVRA. Well, 4 of them have been to purge people, and 1 of them have been to increase voter registration for people who are receiving public benefits. And that actually takes the law and turns it on its head. The final thing I'd like to say is that the issue of voter ID. Now, I filed an amicus brief in the Indiana case attacking the voter ID on behalf of 29 scholars and historians across the country who said that basically a lot of good government reforms, which is what I think a voter ID bill is. And by the way, let's just call it like it is. The Justice Department was not asked to file a brief in the Indiana voter ID case. The most divisive issue of our time in the area of voting rights right now is voter ID. And the Bush administration politically jumped into that case. Sure, they have an interest in federal voting rights, but they didn't have to do it, and they certainly could have presented a more balanced argument for it. But the fact is, and I'll close with this, you have a better chance of being struck by lightning than you do finding a person impersonating another at the polls. And a photo ID isn't going to correct that one bit. You talk to any law enforcement officer and they'll tell you the technology's out there to make fake IDs as easy as the real ones. Thank you, Mr. Chairman, and I'll look forward to any questions that come later.
Thank you. Mr. Shelton is recognized for 5 minutes.
Thank you very much, Mr. Chairman, and good morning. As you mentioned, my name is Hilary Shelton, and I'm director of the NAACP's Washington Bureau. The NAACP currently has more than 2,200 membership units with members in every state across the union. I'd like to begin by thanking the chairman, Chairman Conyers, and many other members of the committee for holding this hearing today. The right to vote is clearly the cornerstone of our nation's democracy. Throughout our nation, the NAACP and countless Americans have fought and died to protect the right of people across the globe to cast a free and unfettered ballot and to have that vote counted. We owe it to these men and women and their families to ensure that the right to vote is protected here at home. Sadly, our struggle is not yet complete, as there are still voter suppression throughout the United States. What is even more disturbing than the continued existence of the Americans being denied the constitutional right to vote, however, is the fact that for the last 8 years, the U.S. Department of Justice has not been our partner in trying to stem voter suppression. In fact, given the fact that the U.S. Department of Justice filed an amicus brief in the case of Crawford v. Marion, Indiana County Election Board, which the Supreme Court heard just last month, many would argue that the current administration is actually working against the goals of all Americans enjoying their constitutional right to vote. And as any major national civil rights organization can tell you, the number of voter suppression cases brought by the current Department of Justice does not even begin to reflect the number of complaints that we receive from the folks across the nation who believe their rights have been violated. In fact, although the number of voting rights violations is very difficult to measure, the NAACP, as well as representatives from almost every civil rights, voting rights organization, all report an increase in the number of Americans, primarily racial and ethnic minority Americans, who say they have been denied their constitutional right to register and cast their votes. Furthermore, attempts to pass laws at the state and local levels, as well as at the federal level, that restrict or effectively shut out entire segments of the population are on the increase throughout the nation, and they are not being challenged by the current administration. Specifically, the NAACP has seen a dramatic increase in the number of cases in which people have registered to vote, believing, having been told that they have done everything correctly, only to be turned away from the voting booth on Election Day and being told that they are not on the rolls. We know that the 2000 election in Florida, a debacle that overzealously purged from the rolls, especially in neighborhoods with heavy concentrations of racial and ethnic minorities, can be a standard trick by unscrupulous or corrupt election officials trying to suppress a certain segment of the voting public. Now it appears that not even putting these people on the rolls is the new popular tactic. Another tactic being used to keep racial and ethnic minority voters and low-income voters out of the ballot box is the enactment by legislatures and governors sworn to protect the rights of all their residents of laws to require government-issued photo identification documents before voting. While supporters of these initiatives purport to be combating voter fraud, a problem which, as numerous studies have shown, is not really a problem, what these laws are in fact doing is creating a barrier to keep up to 20 million Americans who do not have government-issued photo IDs out of the ballot booth. And I would hasten to add that a disproportionate number of these people who do not have government-issued IDs are racial or ethnic minorities or low-income Americans. Finally, I would like to talk for just a brief moment about an issue that the NAACP was intimately involved in crafting, that is the 2002 Help America Vote Act. This legislation, which was enacted in response to the election debacle of 2000, has been underfunded and undersupported since its enactment at almost every turn. While the NAACP and other civil rights organizations strongly supported HAVA, in part because it was seen as a sign that the federal government took voting rights protection seriously, the fact that it has been largely ignored is discouraging, to say the least. To close, I'd like to share with the subcommittee some thoughts shared by the NAACP and the Mexican American Legal Defense and Education Fund, that is MALDEF, one of the premier civil rights organizations invested in protecting the rights of Latino voters. Racial and ethnic minority voters require that the Civil Rights Department of the U.S. Department of Justice be fully staffed with well-qualified attorneys and experts who are committed to addressing voter suppression and protecting minority voter rights. While the NAACP and MALDEF and other civil rights organizations frequently bring legal actions on behalf of racial and ethnic minorities whose voting rights have been infringed, private individuals and organizations lack sufficient resources to guarantee free and fair elections for all voters nationwide. Mr. Chairman, members of the subcommittee, the disenfranchisement of voters who are disproportionately racial and ethnic minority Americans due to the mismanagement of registration bases and the restrictive laws and regulations that are akin to discriminatory poll taxes presents a much larger threat to our national fabric than the many so-called threats that we have been spending untold billions of dollars defeating. Unless all Americans feel that they are vested in our nation and that they have a voice in their government, the promise and security of democracy is hollow and left unfulfilled. Furthermore, I would argue that the inaction of the U.S. Department of Justice's Department of Civil Rights to address voter suppression is not only unethical, immoral, and counterproductive, it is flat out wrong. Thus, I again thank the subcommittee for holding this hearing and inviting the NAACP to testify, and I look forward to your questions.
I now recognize Mr. Emmer for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Franks. Thank you for the invitation here today. My name is Tom Emmer, and I'm a state representative from the state of Minnesota. The United States Congress has enacted numerous requirements, including registration and identification requirements designed to increase the number of citizens who register to vote while simultaneously protecting the integrity of the electoral process. Some of these initiatives include the Help America Vote Act of 2002, which requires voters to provide proof of identification before registering or casting their first ballot, providing the Attorney General with the authority to prosecute voter fraud in federal elections, requiring acceptable forms of identification under the Help America Vote Act, including a current and valid photo identification or a current utility bill, bank statement, government check, paycheck, or government document that shows the name of the voter. The Help America Vote Act also provides that states may provide more strict rules and regulations regarding voter identification. Since the enactment of this act, several states, including some well-publicized cases and challenges in Georgia and Indiana, have proposed voter identification bills. The bills were specifically designed to require photo identification. In a world in which we have much turmoil and such contested elections, it is imperative to maintain the integrity of the electoral process and thus the public confidence in that process. Voters want to know that their vote counts and will not be canceled out by a fraudulent vote. We simply must have something in law that allows us to confirm that we are who we say we are on the day of the election. The American public agrees with this concept. In fact, national polling shows that almost 80% of American citizens agree that photo identification should be required to verify identity prior to voting. Voter identification laws are designed to prevent voter fraud in our elections. There is no question that we have a problem with fraud. The Carter-Baker Commission made such a determination in its 2004 report. In addition, there are numerous examples from other states that demonstrate how fraud has played a role in elections. We as elected officials are slowly realizing the destructive force this has on public confidence in the strength of their vote and the outcome of the election. In 2004, for example, the Indiana Supreme Court, in the case of Cabey versus Pastrick, found that widespread fraud had rendered election results, quote, inherently deceptive and unreliable. The Indiana Supreme Court invalidated a 2003 East Chicago mayoral primary based on evidence of rampant absentee voter fraud, which included the use of a vacant lot or former address in casting of ballots by non-residents. At the same time, the state of Indiana was experiencing highly inflated voter registration rolls as a result of 35,000 deceased individuals remaining on statewide voter rolls. Incredibly, the list of registered voters in 2004 was actually inflated by some 41%, including well over 200,000 duplicate voter registrations. In fact, on April 7, 2005, the United States Department of Justice informed the Indiana Secretary of State that numerous counties had registration totals that exceeded their voting age populations. This is an important national issue. It is not a political issue and should not be. Despite efforts to the contrary, some people are selecting to turn photo identification into a political issue that destroys the very nature of election integrity. Protecting the integrity of our elections and ensuring the validity of the votes cast in the electoral process is important to all of our children and communities, is important to the future of our freedom and our democracy. Those that are challenging these laws that voter photo identification somehow violates the First and 14th Amendment to the United States Constitution because it imposes an unwarranted burden on the right to vote. In fact, they take this position despite their inability to identify any concrete harm stemming from a potential photo identification voter law. In fact, despite the predictions of widespread disenfranchisement resulting from the photo ID regulation in Georgia, no plaintiff in any Georgia litigation, either as an individual or as an organization, demonstrated any injury. The fact is that despite apocalyptic assertions of wholesale voter disenfranchisement, there is not a single piece of evidence of any identifiable registered voter who would be prevented from voting. It is commonplace in virtually every polling place in America that voters are asked to identify themselves before they vote. A state's interest in deterring voter fraud before it happens is important. As the Seventh Circuit Court of Appeals has recognized, in-person voter fraud is extremely difficult to detect. Without a photo ID requirement for in-person voting, it is nearly impossible to catch an imposter. As the pre- and post-voter ID study and analysis is established in Indiana after the implementation of the Indiana voter ID law, there was an overall county-level turnout increase of almost 2 percentage points. There was an increase in relative turnout for counties with a greater percentage of minority and poor populations. There was no significant impact on turnout in counties with a greater percentage of less educated or elderly voters. And as has previously been noted today, there was a significant increase in turnout of Democrats. Thank you for inviting me again here today, and I hope that this committee will give serious consideration to what should not be a political issue, and that is proving who we are when we step up to the polling place.
Thank you. Professor Minnite is recognized for 5 minutes.
Thank you, Chairman Nadler, and thank the members of the committee for inviting me to testify today. I've submitted a written testimony that explains in a lot of detail the research that I've been doing over the last several years on this question of voter fraud, and I'd like to just take the few minutes that I have here to highlight a couple of points. One is the purpose of this research. As a political scientist, we study voting behavior, and the prevailing theories of voting suggest that, in fact, it may not even be rational to vote, let alone to vote twice. So when the rhetoric of fraud really got ramped up after the 2000 election. I thought it was an interesting puzzle. On the one hand, we were hearing lots and lots of stories of all kinds of fraud, of the system being very vulnerable to fraud, of there being an epidemic of voter fraud. And at the same time, the academic side, I had colleagues looking at me and asking, why are you studying this? There's very little academic research on it, and in fact, it doesn't make sense. The incentives have to be huge for an individual voter to commit fraud. In the absence of a conspiracy, there's no rationale for a voter to take the effort to commit a felony crime, to vote twice, or to vote in the name of someone else. So it was an interesting puzzle. That's how I approached it. And I began by trying to look at the empirical record. And I want to address what I think are some mischaracterizations and misunderstandings about what that record shows. I want to focus specifically on the federal government's effort here to root out voter fraud. We heard the number 86 people. The research that I've been able to do, and it has been quite difficult actually to get the data from the Justice Department, but the research that I've done to look at the success of the Ballot Access and Voting Integrity Initiative, which the Justice Department began in 2001-2002, shows that between October 2002 and September 2005, there were only 40 voters indicted for any kind of a crime related to illegal voting. And I've supplied in the written testimony a table that shows for you a breakdown of the 95 indictments that the federal government brought under this program, which was to address voter fraud and voter intimidation. And when you dig into the data, because you have to dig into it, you find that only 40 of those people actually were voters. Others were government officials, campaign workers, election workers, and so forth. So looking at those 40 voters, there were 26 convictions or guilty pleas. That's a conviction rate of 65%, which is quite low for the Justice Department. When we look at those voters and those who were convicted, we see that one person was convicted for a registration fraud. That person did not even vote, and in fact, that man was deported back to Pakistan for registering to vote inadvertently when he went to redo his driver's license. There were 20 people who voted who were ineligible, and these were people who had felony convictions and had not had their civil rights restored, and also non-citizens, 15 of those, and then 5 people for multiple voting. And most of this occurred over the Kansas-Missouri border. So the record, the empirical record of the Justice Department here, where they have made a vigorous effort to root out voter fraud, has produced very, very little. And in my testimony, I mentioned other things that I've looked at. I've made an extensive search to try to look at state records here. I've used open records requests in the states to request data from every Attorney General, Secretary of State. I wrote letters to 2,700 district attorneys asking for data on this, and I'm convinced that there is no problem with individual voters trying to commit voter fraud. So this first point here is that we must look at this data carefully, and we should look at what voters are doing, because one of the consequences of feeding what I think really has become a propaganda effort to convince the American public that voter fraud is a problem is that there's a lot of confusion about who's committing fraud and where the system is vulnerable, and it's worth taking the time to analyze that. The other point that I want to make, and to conclude quickly, is that contrary to what has been suggested here, there is no evidence that ID laws increase confidence in voting or increase voting. You can have an increase in turnout and you can suppress the vote at the same time. The question in Indiana is how much larger the turnout might have been had the photo ID law not been in place. So I'll conclude with that comment.
I thank the witnesses. I will begin by recognizing myself for 5 minutes. Ms. Minnite, what do you mean when you say that there's no evidence that ID laws increase confidence in voting? What do you mean by confidence in voting?
Well, this is a term that has been used a lot in the media, It can be taken from public opinion polls, which ask people about whether or not they think their vote is going to count and so forth. So most of when people say confidence in voting, I think usually they're trying to rely on public opinion polls that ask people questions that way.
Thank you. Mr. Emmer, you talked about thousands of, I think you said thousands of people who were not removed from the rolls when they died or when they moved. Is there any evidence that any of these people voted after they died?
I don't have any.
Thank you. So now, we know, I mean, this is not a revelation that most states, that when someone dies and moves out of the state, his name remains on the rolls for a few years. But there's no evidence. And now an attempt has been made, including by you in your testimony, to point to that as if it's some great problem. But is there any evidence that there's been any substantial voting by people whose names remain on the rolls because they died, or voting in 2 states because they moved from one state to another, in 2 counties because they moved from one state? In other words, when you move from place A to place B, you register in place B, you don't go normally and deregister in place A. But is there any evidence that there's a problem with that, that people in fact have tried to vote where they used to live as well as where they live, or that people voted for them after they died?
Yes.
What evidence is that?
Well, I started to read it to you. It was the mayoral primary in Chicago, in Indiana, and then there's a couple of other
Excuse
instances.
me. And how many people allegedly voted who were dead?
Dead, I don't know, because it wasn't
All right, how many
broken
people
down that way.
wait, how many people allegedly voted who in fact had moved out of Chicago, let's say?
155 invalid absentee votes is what the research that I did showed.
Invalid absentee votes, which were counted or which were invalidated?
That invalidated it because the race was determined based on a difference of 278 votes.
When you cast an absentee ballot, they validate the vote or not before it's counted. Were these ballots counted?
Originally they were. It was subsequent after a court challenge. My understanding is that's when the court determined.
So ultimately they weren't counted in the election?
Excuse me?
So ultimately they were not counted in the election?
Ultimately the election was determined to be flawed and it was thrown out, the results.
The Chicago mayoralty election?
The East Chicago mayoral primary in
Chicago,
Indiana.
okay.
Yes, sir. I'm sorry if I confused the chairman.
Mr. Hebert, could you comment on this? Is there much evidence, or Ms. Minnite, I'm not sure who to ask, that lots of people vote, that there's a substantial problem of people impersonating dead people voting or impersonating someone else voting?
Well, first of all, there is not a voter fraud epidemic out there of people impersonating others. As I'm sure every member of this committee knows, it's hard enough to get people to show up to the polls once, let alone trying to convince people to show up twice and vote for somebody else. Let me just say that with regard to Mr. Emmer's case, and there are cases out there that involve voter fraud occasionally being committed by somebody in connection using absentee ballots. But a photo ID requirement doesn't have any impact on an absentee ballot. Those are votes that come in by mail, and there's no photo ID involved there. So
let me ask you a different question. Is there 86 voting fraud cases that the department prosecuted, Ms. Minnite? How many of them involved impersonations that a voting fraud, that an ID card, a photo ID card might catch, of those 86?
Well, I'm not sure exactly where the 86 number comes from, but if you look at the 95 indictments brought between 2002 and 2005, none of them involved voter impersonation.
Mr. Emmer, you argue that we have this epidemic of fraud. How many cases have been how many convictions have we had of people impersonating other people?
Mr. Chairman, with all due respect, that wasn't my argument. That my problem here is that there is...
Oh, wait a minute. Your argument is that a voter ID card is essential to prevent fraud. Aside from impersonation, what other kinds of fraud would a voter ID card prevent?
The voter ID card, and I'll give the example that Mr. Hebert said, it would have nothing to do with absentee ballots. In fact, this is why these cases are so rare. Without a voter ID card, Mr. Chairman, with all due respect, you can't determine whether or not fraud has occurred.
Wait a minute. In an absentee ballot, someone signs a ballot, mails it in, they compare it to the records they have. How does a voter ID card have anything to do with that process?
Well,
how could it?
After the fact, you would use we have in Indiana and Georgia, I believe it is, you get 2 days when you do a provisional ballot, much like an absentee ballot, to confirm that in fact you are who you say you are when you fill out
but in a provisional ballot or an absentee ballot, you mail it in. I'm going to be in Russia. You mail it in, and you fill out the information. I'm so-and-so. I live at such and such an address. I'm a registered voter, and so forth. They take that. They compare it to the records. They compare your signature. In a provisional ballot, where for some reason your information is not at the polls, you sign an affidavit which you say, I am so-and-so, I live at such and such an address, signed so-and-so, and I'm entitled to vote, signed so-and-so. They take that after the election, after Election Day, I should say. They take that, they take it to the Board of Elections, they compare that information with the information they have, they compare the signatures. And they either say it's the same person or it's not, and they count the ballot or they don't. In either case, how would a voter ID, a photo ID card, come into the picture one way or the other?
In the example that you just gave me, Mr. Chairman, it would be, in fact, if there's any necessary investigation after comparing the actual absentee ballot to the signature on the voter rolls. If somebody determined that they needed to further investigate whether or not that signature was valid.
Once you've compared the signatures, there's no further investigation.
If somebody determines that that is satisfactory, you're right. You're correct, sir.
And if someone determines it's unsatisfactory, now you're dealing with a criminal allegation that someone forged a signature. Photo ID card is irrelevant. You call in the person and you say, prove you're so-and-so. You don't need the card at that point. It wouldn't help at that point.
Well, it may or may not. I will agree with the chairman.
So where would it, so the only thing that it would help then, aside from this situation where it wouldn't help in 99.9% of the cases, is if someone shows up to vote and says, I'm Joe Smith, when in fact he's Joe Jones. How many proven instances of that do we have?
Well, and that's the problem. Therein lies the problem. Without a photo ID, how would you ever know?
Mr. Hebert, could you comment on that, and then I'll yield the floor.
Yes, this is a common thing we hear. Prosecutors have all kinds of resources. First of all, when you go to the polls to vote, for the most part, the people who run the polls are neighborhood people who live in your neighborhood who know you. And so when you come back, if you were to claim that you are so-and-so there to vote, and you attempt to vote and you impersonate somebody else, and then that person comes to vote later in the day and they say, I'm sorry, you can't vote because you already voted, that person probably would vote a provisional ballot, and the district attorney would then have an opportunity to go ahead and prosecute the person who showed up first. And you think to yourself, who is going to take that risk, given the current felony statutes that are on the books, to go and commit voter fraud with eyewitnesses like voter officials who are going to witness you committing the voter fraud rather than commit it through some more subtle means like absentee voting?
Thank you. My time has expired, and I recognize the distinguished ranking member of the committee, of the subcommittee.
Well, thank you, Mr. Chairman. Mr. Chairman, you know, I just want to repeat what's been said many times here today, is that the process of our voting and the process of our elections are critically important to this country, because our confidence, and not only our confidence, but their actual accuracy, is a foundation of the nation. With that said, I would readily admit to the majority that sometimes when I hear about voter fraud, there are a lot of instances that you hear about, and it does seem that the evidence indicates that that's less than what you hear about in the public. If you take polls, there's a lot of people that are concerned about voter fraud, and maybe it's less than what people think. But isn't that the point? Part of the issue here really is about the public's understanding that their elections are secure. There were, I think the testimony here has been anywhere from 40 to 86 indications of voter fraud, and yet the testimony here today has been that there has not been one court that has ever ruled that anyone was prohibited from voting because they didn't have the proper ID based on those allegations. And so, you know, I don't discount the majority's concern about some type of ID card, you know, trying to make sure that that doesn't prevent someone from voting who has a right to. So consequently, I think it's unfair to discount the concern over voter fraud. But with that said, I think there's a different issue here involved as well. I think that the people of this country have a right to believe that their elections have been made among those who were who they said they were, as Mr. Emmer has said. And there's another issue sometimes. You know, I mean, in Mexico, the last election they had two people pretending they were president for a long time because there wasn't confidence in the system. And there wasn't any way to be able to put that out of people's minds. And I think that a voter ID that was universally accepted is one way to create confidence in the system. But let me just, if I could draw everyone's attention to two letters that were sent about a month ago that I think illustrates the confusion that can take place. These were letters that were sent to the Democratic Party of the state of Nevada. And I want to ask the panelists whether they think that there's any potential federal election law based on the following allegations made by the Clinton campaign for president. The allegations were that caucus chairs who obviously supported Mr. Obama were, number one, deliberately miscounting votes to favor Senator Obama. Number two, were deliberately counting unregistered persons as Obama votes. And number three, were deliberately counting young children as Obama votes. They all went on to say many Clinton supporters were threatened with employment termination or other discipline if they caucused for Senator Clinton. Now, if those allegations are true, maybe they're just campaign rhetoric, but if they were true, Mr. Emmer, would they be potential federal election campaign violations?
Well, I would say yes. I would say yes, and that's, well, the answer is yes.
Yeah. Well, let me shift gears and let's give the Obama campaign their fair due here. This is allegations made by the Obama campaign, and these are quotes. This is written to the Nevada State Democratic Party in written form. Those Hilary people closed the doors on our people, and we had to call the cops in some precincts to have the locks cut from the doors. They slipped people in the back doors. They sent people home at 11:30 when it was illegal to prevent people from voting before noon. In Precinct 21, a Democratic worker who was clearly for Hillary refused to register Obama supporters and said she was only registering Hillary supporters. Another one, almost immediately I was told by a couple of other Obama's precinct leaders that the Hillary people were turning our supporters away by asking to see their IDs and telling them they weren't valid. Mr. Emmer, I ask you a question again. If those allegations were true, and again, I have no idea. I mean, it sounds to me like just campaign bickering. But if they were true, would they be potential federal elections campaign violations?
I believe they would.
Yeah. Well, I think the point I'm making here is, do you think then, and I'll give others a chance to respond, do you think that there are potential, if that's true, do you think that a universal ID card that was universally accepted would have at least been able to dispel those kinds of allegations to some degree?
It may have, and Ranking Member Franks, what I would add is the public is asking for this. 80% of Americans are asking for it, so it's not just the example that you're giving which would warrant it, but the public across all different races, religions, creeds, walks of life is asking for this.
Well, my point exactly. Mr. Chairman, I'm going to yield back as my light's on. I'm sorry.
Thank you. I now recognize the gentleman from Virginia for 5 minutes.
Thank you, Mr. Chairman. I couldn't help but notice the fair and balanced approach that the gentleman from Arizona used. He criticized all of the Democrats. That's, I guess, bipartisan, his view of bipartisanship. Anyway, Representative Emmer, we've been warned by the old adage that to avoid situations where the cure is worse than the disease. We've heard about the handful of fraudulent cases that would possibly be cured with voter ID. How many people would be prevented from voting because they couldn't get their paperwork straight in order to register?
Mr. Chairman, Member Scott, none.
I'm sorry?
None, sir.
Okay. You don't have to find a birth certificate or something?
Mr. Chairman, Member Scott, I'm sure you're going to have to put together some paperwork, but as the experience has shown in several states over the last couple of years, absolutely no one, there is no evidence that anyone has been denied the right to vote. In fact, cases in Georgia have been dismissed for that very reason, because plaintiffs can't meet their burden of proof.
Mr. Shelton or Mr. Hebert, are there examples of people that couldn't get their paperwork straight in time to register to vote under the voter ID laws?
Absolutely there is. And in Indiana, for example, the Marion County, which is where Indianapolis is, filed a brief in the Supreme Court of the United States in which they talked about the people who actually who had been denied the right to vote as a result of the inability to produce the necessary documentation. There are other examples. Remember, too, when the Indiana voter ID case was brought, they had never had an election yet under the voter ID when the case went to trial. So, you know, I think it's a little misleading for people to get up there and say, well, in that case, the court didn't find a single instance of a voter being denied the right to vote. But as it turned out, once the election was held, yes, there are really horrendous stories of veterans denied the right to vote even though they were already registered to vote.
Let me just add that the NAACP held a series of hearings from the 2000 election, the 2004 election in Florida, in Ohio, and other places across the country, where numerous people testified they were not able to meet that burden and provide the paperwork you're describing. As we talk about that paperwork, we also have to talk about it in the context of what it costs to actually get a certified copy of your birth certificate, or in some cases, they want a copy of your passport for those that have it. We're talking about expenses that run $35 and up in most states across the country.
Mr. Shelton, in your hearings, did you find examples of people intentionally misleading others about their eligibility to vote or how to vote or when to vote?
In terms of their, yes, sir, in terms of their eligibility and when to vote and how to vote, there were documents sent out, misleading documents in various communities, even right here in Prince George's County, but other places across the country in which misinformation was distributed about what time the vote was going to take place, where voting sites were. In one case, they were told if you were a Democrat, you can vote on Wednesday, but Republicans would vote on Tuesday. Of course, Tuesday was Election Day. We've also had examples of robotic phone calls going to people, in many cases misleading, and telling them that very well, we're testing out this new system. You can vote by telephone today. So if you want to vote by so-and-so, you punch the number 1. For such and such, you punch the number 2. And then when the call was over, after they went through the ballot, they told them, because you've been such a great participant and because of your voting history and done such an excellent job in the past, don't worry about coming out to the polls to vote on Tuesday.
Thank you. Ms. Minnite, are you familiar with the report issued by the Asian American Legal Defense Fund?
I'm familiar with it.
Can you talk about the what response there has been to the allegations of excessive requests for identification for Asian Americans?
That I don't know.
Do you know if there's any response to the allegation that there was lack of interpreters at polling places?
I don't know the response. I'm assuming you mean by the Justice Department or by election officials?
Election officials, just somebody.
Yeah, no, I don't know that there's been any.
And or clerical mistakes or lack of information available to help people actually cast a vote?
No, I don't know.
Mr. Hebert, are you familiar with those allegations?
I'm just generally familiar with them. I represent the City of New York Board of Elections. That was a lawsuit was filed against the city because there was allegations of ineffective assistance at the polls provided to Asian American voters. The city ended up settling the case and, in fact, now has pending for preclearance what we think is a pretty effective plan that remedies some of these same problems, at least in New York City. There are other problems, though, in other cities that are still remain unremedied, and the Justice Department's long litany of 27 cases or whatever it was they said they had filed, a lot of those are against little bitty counties in some rural place, and the allegation was you violated Section 203 of the Voting Rights Act because you didn't put a sign up saying that, there was a bilingual election law in effect. And the officials generally, in the Justice Department, you don't want to use your resources that way. You want to take on the big ticket items that private litigants can't do. That's what you do at the Justice Department. So, again, there's lots of allegations like that, Mr. Scott, and that report contains numerous examples of them.
Mr. Scott, if I might also add that both MALDEF, the Mexican American Legal Defense and Education Fund, and the Asian American Law Center testified before the NAACP in 2006 that indeed the types of cases you're describing were a major problem in a number of areas, both throughout the South as well as throughout the West. We have copies of that testimony. We'd be delighted to provide it to the committee.
Thank you.
Thank you. The gentleman's time has expired, and I recognize the gentleman from Minnesota for 5 minutes.
Thank you, Mr. Chair. Let me greet Mr. Emmer. He and I we're serving the Minnesota State House together. We disagreed on most policy issues, but we did agree on some, particular data privacy issues, and it's good to see you here again, Representative. You know, you mentioned some things that happened in Indiana, but let's talk about the state you and I know best. In Minnesota, we have some of the highest voter turnout in the country, don't we?
We do.
And in general, we're either 1 or 2 in the country, election after election after election. And we also have some voting laws that that make it easy for people to vote, such as same-day voter registration. Isn't that right?
I'm sorry, Mr. Chairman, Representative Ellison, I didn't catch the last
Yeah.
part.
We also have rules that make it easy for voters to cast a vote, such as election day registration, right?
Yes, some would say that makes it easier.
And also we have vouching, which means that if you live in the precinct and you can verify that you know this person lives in the precinct, even if they don't have an ID, they can register and vote on that day. That's a rule in Minnesota, right?
That is Minnesota.
Yeah, and we don't have any, well, can you tell me whether we have any verifiable fraud in Minnesota?
We have had some allegations, but as far as I know, there have been no outright prosecutions in the last 2 to 4 years.
Yeah, so we got highest voter turnout, same-day voter registration, vouching, and no verified proven fraud at all. Now, we did have a case in Red Wing. Do you remember that thing?
No.
Not Red Wing, Red Lake, I'm sorry.
That one I remember.
Yeah, the Red Lake one. You know, you're quicker than me on that one. Red Lake. Do you remember the Red Lake incident? Remember the Red Lake incident?
I do vaguely. Perhaps you could refresh my recollection.
Yeah, let me do that. In 2004, a Native American Indian reservation on the far west part of our state reported that somebody from Washington came there and was challenging every voter, regardless as to having specific information, because in Minnesota you can challenge a voter. And the tribal authorities actually had to escort this person off the reservation because they were creating such a nuisance for Native American voters. You familiar with that case? You remember that one?
That is very unfortunate. We have the same problem in Minneapolis and St. Paul with Republicans when they go to vote.
Yeah, that's a good joke. I appreciate that. But let me just ask a few other questions. Is there any, thank you, Professor Minnite, for your work. I'd like to ask you, I looked on your chart and I couldn't find any demonstrated or documented cases of imposter voting, specifically imposter voting. I'm voting today, I am not who I say I am, here's my fake ID, and I voted. Are there any cases of that you were able to discover?
Not in this data, not in the federal record here, no. I'll add, the one case of impersonation that I know of and looking, for years now and looking quite hard, was a case in a Republican primary in New Hampshire, I think it was 2002, in which a 17-year-old who shared his father's name and knew that his father was going to be out of town, went and voted because the polling site was in his school, and the teacher had taken the class down to say, here's, we must exercise our civic duty and stuff, so when you turn 18, vote. And he knew his father was out of town and that his father wanted to vote for George Bush. Sorry, so it must have been 2000. And he voted, but in that case, an ID card obviously wouldn't have worked because he had the same name as his father. So that is the only case that I have come across in which you might say there was a kind of impersonation going on.
Now, I'm familiar with that case. And my recollection was that it was New York, but it could have been New Hampshire.
It was New Hampshire.
Was it?
Yeah.
And in this particular case, I recall that kid getting a criminal record.
No,
or some sort of a juvenile.
He had a community service requirement, and he was also required to make a speech to his class about integrity in the voting process. But they didn't want to give him a criminal record for that.
Yeah, and so that's the only case I've ever heard of. Let me ask you this as well. What is really going on here? I mean, we've had a lot of people say that we got to have these photo IDs because we got to have integrity in the vote. I haven't heard any proof that people don't have and don't believe that's a widespread problem, and the number of cases are woefully inadequate to support the case. But we have this big PR campaign going on, and now what we're seeing is scholars like yourself saying, there's no there. So what is really going on? Why the big furor about voter fraud? Mr. Shelton, would you venture to enlighten us a little bit?
I believe it's an attempt at voter suppression. That we know that the poorest of Americans have a tendency to be racial and ethnic minorities. They have a tendency to vote in one direction for a particular party. The thrust of this seems to be the other party pushing against those participants being able to cast that vote and have that vote counted. We've had other experiences in which African Americans would go to the polls in places that do have a photo ID requirement. And when the African American came to the poll to vote, because the poll workers have the discretion to actually accept other forms of identification, even signature attestation, which, by the way, is the most effective and surefire way to prevent any kind of misrepresentation, that very well they were being sent home to pick up their photo IDs to come back. But the white voters that lived in the same community were allowed to cast votes even if they didn't have the photo ID on themselves. Indeed, we're seeing a discriminatory application of the law that cuts across racial lines and cuts across lines of not only employment but certainly income.
Mr. Chair, can I ask unanimous consent to have this University of Wisconsin 2005 study entered into the record?
Without objection, so ordered.
Am I out of time?
Yes, you are. I thank the that is our last questioner. I thank the witnesses. Without objection, all members have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward, and ask the witnesses to respond as promptly as you can so that their answers may be made part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. Again, I thank the witnesses, and with that, this hearing is adjourned.
Thank you very much. I don't have, I didn't bring it. Do you have one? I'll send you a note. Okay. How you doing, Tom? I'm doing great. There was a dinner invitation. I didn't know you were coming, man.